Hello, hello, everyone. Welcome to Medical Monday and another episode of Should You Take That Case? The goal of our show, as always, is to be a resource for legal professionals who pursue medical cases by sharing their experiences and insights as defense or plaintiff attorneys. I'm your host, Lisa Wade, friendly neighborhood legal nurse consultant, owner of Wade Nurse Consultants. Think of us when you have those tons of medical records that you need summarized and reviewed and translated into normal human language. And I'm also the creator of the Attorney Medical Record Resource Group. That's where we get all of our stellar attorney guests. That's where they all come from. And we use this as an opportunity to get to know one another. And we're doing that today with Evan Walker from California. Now, before I bring Evan out, let's toddle over to the chat and see who's visiting us live. If you're there visiting us live today, put an A in that chat if you're an attorney, a P if you're a paralegal, an L if you're a legal assistant. But if you are part of a group I love, Women Owned Law, put a W in that chat. It's one of my favorite groups. It's a groundbreaking group created to connect and advance women legal entrepreneurs. And visit us at womenownedlaw.org if you want to learn more. I want to thank everybody that's watching us today, taking all of this time out of your very busy days or catching us on the replay. We definitely appreciate you being here. And now it's time to bring out my guest for today. Let's see. There you are, Evan Walker.
How are you?
I'm well, thank you. And yourself?
I'm doing well.
All right, sunny California.
It is sunny.
All right, well, that's good. Well, it's just hot here in Pennsylvania. So I don't know. It's not sunny. It's not funny. It's just hot. Well, thank you for being with us today. And hey, how about you tell us a little bit, introduce yourself, tell us, all about where you're from and what kind of law you're practicing. Give us the lowdown.
Sure. So my name is Evan Walker. I'm a plaintiff attorney who practices here in San Diego. About 65% of my practice is serious personal injury cases. The other 35-40% are high-end property damage cases. So we're talking fire, flood, disputes with insurance companies, things like that. And I'm from a small town outside of New Orleans. I lived through Hurricane Katrina, wound up doing defense work right after Katrina, defending insurance companies on Hurricane Katrina claims, which is how I got into property damage. And then I spent some time on the East Coast with my wife who was doing her medical training. And I worked for a large insurance company there doing defense work. And then we came out in California in 2014 to continue her medical training. And I took the bar out here and opened my own practice in 2015. And I've been doing it since.
All right. Well, the East Coast to the West Coast is a giant difference.
Yeah, it's different. For sure, it's different. I mean, practicing law in Louisiana and Connecticut and California, there are some similarities, but it allows you to appreciate that law can be state specific and there are differences for sure.
Mm-hmm. All right. Well, tell us a little bit about, how did you end up getting to be an attorney? Was that decided at birth or some other kind of way?
Yeah, not anything dramatic like that at all. So I was a philosophy major and I graduated college and I just spoke to an advisor basically on my way out of the door with no real plans. And he said, "Hey, did you ever consider going to law school?" And I said, "No, I didn't, but that's a great idea." And like 2 or 3 weeks later, I took the LSAT And then I applied and I got into law school, Loyola, New Orleans, and there you go. It's not any more complicated than that.
Oh, easy peasy. Excellent. All right. Well, how about tell us a little bit about how you get your cases? How do you decide whether there's a good case for you to take? Should you take that case, or maybe you should pass that along or refer it somewhere else? But how do you decide?
Sure. So to answer your two questions, how I get the cases, at least my understanding from potential clients and clients that reach out to me, it's they find me online, right, or a referral or something along those lines. I don't do a ton of advertising, but people do find me online for various reasons. Maybe some article I'm mentioning or some resource that I put out there. To your second question, it really depends. So, like I said in the beginning, I have my niche and that's what I stay in. I don't really venture out of that. And because I'm a true solo, it's just me. I don't have, and it's by choice, I don't have a huge caseload. And so I'm very particular in the cases that I take. So it has to fit into my practice area. And beyond that, it has to be a serious personal injury and it has to be a significant property damage. And that usually is in monetary terms. There's a certain, if the damages are not a certain percentage, I'm just not going to get involved because honestly, it's not a good business decision for myself and not really for the client, just because of the complexity and cost of litigation. So if we meet those two kind of hurdles and I have the capacity and it looks like I could actually help the client, then those are really the qualifications that have to be met in order for me to, start the representation, assuming the client wants to go forward.
Okay. Well, it sounds like, not having a big caseload, you get to be a little choosy about
Right.
about what you're doing.
Right.
Well,
Sure.
and when you say you solo, you mean like nobody else is in that office?
Yeah.
No
Yeah.
secretary?
It's been that way since 2015 and it's by choice. I love it that way.
All right. Well, it's very quiet there, so that's good.
Yeah.
All right. All right. And when you guess what? We have one of those unusual comments, and I'm going to just show you real quick. Stephen Haber, I think you've got a fan, Stephen Haber Esquire. He said that Evan, that you did a nice CLE lecture. Did you do that recently?
I've done a number of them. I think I know which one he's talking about with attorney credit. So yeah, thanks for the shout out. I appreciate that. I hope the CLE was helpful.
Oh, well, hey, yeah. He said, "Yep, yes, it was." There you go. All right, go, Stephen Haber. Hi.
Thank you.
He's a past guest.
Nice.
He's a good guy.
Nice. Yeah.
All right. So let's dive into a little bit more the details about medical records. When they come up during these cases, they rear their ugly heads. And is there a specific protocol or procedure that you have to dive into them and get all that information that you need?
Yeah, it really depends. Just like with almost everything in life now, everything is different post-COVID. And I know that it was such a slog to get records post-COVID because, and rightfully so, it wasn't a priority for the medical records department, to be fair to them. And I get that. And so my process has changed a little bit since COVID. That's number one. And then number two, I simply don't take the amount of cases like I did before. So like I said a minute ago, I'm particularly selective in the cases. And so I may only have a handful of cases. So I don't have this huge caseload where I have to kind of rely on these outside vendors and do this and do that. With those caveats, my general practice recently is depending on the provider. Here in Southern California, we have Kaiser. So a lot of clients are Kaiser patients. And then we have another large hospital group here, Scripps. What they've done is they made it a lot easier now for clients to simply get on and request the records with the click of a button, and then it could be sent to me or to them. And that's usually what I've been doing. So it's just a matter of 1 or 2 page authorization forms. You submit it, and then the providers email me, 1,500 pages, and that's that. And I think it's done under the HITECH Act, which I'm sure you're familiar of, but that cuts out a lot of work and it saves a lot of time. And since I'm a paperless office, there's nothing to scan in. So it's already coming to me PDF. And then if it's not OCR'd, I OCR it and I'm good to go.
Oh, you've got a lot in common with Stephen Haber. He is paperless. He's been paperless a long time.
Yeah.
So maybe you two of you can get together and chat a little bit. So I'm going to give your contact information. All right. Excellent. All right. So, well, when you do dive in and you get those records, which seems to be Kaiser makes it easy for you, you have them in hand. Do you find anything that's very difficult or puzzling or bothersome? Is there a pet peeve you have regarding reviewing those records?
I mean, I wouldn't say there's not a pet peeve. The issue that comes up, and this is speaking generally for practitioners in this field and specifically for myself, is a lot of times you may be unaware of the medical nomenclature and you come across terms you're not familiar with. And so you really have to get as versed as you can, knowing you're not medically trained, but you need to get as versed as you can to understand some of the terminology and to understand kind of what you're looking at. And when you read the records, know what to look for and what the terms mean. And so what I have in my materials that I use are medical diagnostic books and medical dictionaries, and of course the internet. So you could start to look up the terms instead of kind of guessing from the context what you think it means. And so to kind of use those materials to supplement your review of the record. So frankly, you have a general idea of what it exactly is you're looking at.
Mm-hmm. Well, yeah, I understand some of these things, these abbreviations, they're counterintuitive. They're not really what you think they should be. So, yeah, having some good resources, that sounds like a good idea when you're reviewing those records. And I just, you've given a lot of good information and told us a lot about yourself. Now, tell us if you have any other advice on your mind that you would give to any new or veteran attorneys when they get these medically related kind of cases, and how should they decide if they should or shouldn't take that case? Any other words of wisdom?
Knee-jerk reaction to that is and then this is just one man's opinion, is from the get-go, you need to decide what type of cases you're going to take. Like, for example, I will never take a medical malpractice case, ever. That's just a rule. Never take it. And so I know if it's a medical malpractice potential, I'm referring it out. I will never take that case. And so I think it's good to know before anyone even calls you what type of cases you take. Like I said in the beginning, for myself, I know that there are certain qualifications that have to be met once I decide to get involved. And then if it meets those qualifications, you can start to get involved. But you should have at least a general understanding of what you're getting into, right? And I understand plaintiff work, each case is arguably different, but I think it's good at least to have some limited background knowledge and not kind of learn on the fly with this case, because I don't think that's always fair to the client you're representing.
All right. Sounds like good, solid advice. And I'm glad you're here sharing all of your knowledge and details and experience with us. And now we're at the point in our show when it's time for a little Q&A, if you're ready for that.
Sure.
All right. So while folks are out there looking, getting some questions together, and be prepared to put them inside the comments box so Evan can answer them. While they're doing that, it's time for what I call a tiny sponsor break. So I can tell everybody what happens here at Wade Nurse Consultants. And we'll be right back to Evan. And without a review and summary of the medical records, it might be harder for you, personal injury and medical malpractice attorneys, to know if you should take that case. And here at Wade Nurse Consultants, we give attorneys a 1 to 2 page synopsis and an opinion regarding the merits of those medical cases. And by using my 30 plus years of nursing experience to make quick work of medical case screening. So if you're watching this and you have your own nurse paralegal on the payroll, this isn't for you. But if you have a backlog of cases to screen for merit, feel free to come on over to wadenurseconsultants.com, visit us, and schedule a 20-minute medical record strategy call. I'm going to leave the link to schedule the consultation inside the description box of this YouTube channel. Schedule that medical record strategy call to help you hone an efficient, timely, and a cost-effective routine around your medical cases. Now, it's time to get back to Evan and a little Q&A. Oh, guess what, Evan?
What?
There is a question. And it's from our wonderful attorney, Stephen Haber. And I'm going to put it up there for you. Ta-da. Can you read that for me, Evan?
Does California have a pain and suffering limit? So, no, when it comes to, the general rule is no when it comes to PI cases. The exception is med mal. So there's a $250K limit, and it's been that way since sometime in the 1970s. What I can say is my understanding is that there's been an active push from the plaintiff bar to change that. And I think finally we're going to get that change in next year's legislative session. My understanding is there's going to be a step up increase. And that was in conjunction with the plaintiff bar and their legislative arm. And I think in addition to some of the medical professional lobbying groups.
Oh, well, you see Stephen's response. Ouch.
Right. People have been, it has been a law on the books for over 50 years. So we all know now what inflation means. And so to say that this cap, I mean, it's a cap on med mal damages, has been $250,000 for 50 years. In California, to be fair, $250 ain't a lot of money.
Oh, boy. Well, thank you for your insight to what happens in California. And let's see, do we have any other questions? Stephen Haber, do you have any more questions for us today? Let's take a look. Not yet. Maybe he's typing. Oh, well, if Stephen's typing, let me just say it's been wonderful having you here today, Evan. I really appreciate you coming, spending time with us. And I have a question for you.
Okay.
Are you going to come back again?
Sure, I'll be happy to.
Oh, excellent. Well, I will be inviting you. So watch for my email. And wait a minute. One more comment from Stephen Haber. Don't liens drive you crazy.
Honestly, I could give a whole talk or CLE, Stephen, on this issue. I'm dealing with it right now. 2 cases come straight to mind. Liens are a real problem. In fact, let me just say real succinctly, because I think this may be helpful to your viewers, especially the newer attorneys, and Stephen's spot on about that. I don't want to say a problem, but it's a huge issue. So what can happen in your PI cases is you can get everything settled. You're settled with the tortfeasor, with the third party or whatever. Everything's good to go. Then you have to turn around and deal with the lien providers, the lien holders. So that could be private, that could be public, like Medi-Cal, it could be Medicare. You're getting into ERISA, and it's almost its whole separate set of law. And so you really have to get that stuff down, because you could get a righteous settlement and be good to go, but then realize that the lien company is claiming 40% on it. And it, like I said, I can only speak for California, and it looks like Steven's had some experience. It could be a real problem for the unwary.
Oh, well, Stephen's full of queries, and we got one more. And any wrongful death compromises?
I'm not sure.
Is that and wrongful death compromises?
I'm not sure what that means. In California, we obviously have a wrongful death right of action. It belongs to the survivors of the decedent. There's no cap on that, and there's not going to be any liens, because you're not suing for the pain and suffering by the decedent. It's the decedent survivors that have a claim.
Okay. All right. All right. Did we get that answered for you, Stephen, appropriately? All right. Okay. Okay. We got one more question for Stephen. Can you get that?
Yeah, that'll be easy. I have no experience with that. Believe it or not, in the 7 years of practice, I have not encountered the workers' comp, if that's what he's referring to, WD. I'm not sure. Maybe it's wrongful death. If he's speaking of wrongful death comp, I have no experience in that.
Oh, all right. Well, I think we're going to wind down today, because I think you've answered a wealth of questions for Stephen Haber. And what I'm going to do is, since we're coming to the close, I'm going to tell everybody we're going to have your contact information inside the description box of this YouTube channel. And people can reach out to you, even catching on the replay. Is that all right with you, Evan?
That's fine, sure.
Excellent. And I think Stephen's okay with that. Okay. All right. All right. Well, again, thank you for coming. I really appreciate it. And you're going to come back again. Yay.
Yeah, for sure. Yeah, thanks for the opportunity. It's been fun, and good luck to you and your business and all the viewers.
Thank you. All right. Now, I'm just going to remind everybody that's watching to like our show, subscribe to this channel, and if you have any legal nurse consulting questions, visit me and ask them at Lisa at WadeNurseConsultants.com. But tune in for a brand new episode Monday, 5:15 p.m. Eastern Standard Time, for a brand new episode of Should You Take That Case? And we'll see you then. Thank you.